The American Bar Association represents about a third of the country's 1.2 million lawyers. But it is more than a trade association. It also has some governmental power, which makes its latest foray into political correctness of more than passing interest. States give the ABA power to accredit law schools, which must teach the association's model rules of professional conduct. The ABA also lobbies state courts to adopt these rules, which become real law governing how and whether lawyers can practice. At its San Francisco convention this month, the ABA adopted a rule regulating things from lawyers' speech to the access to their office restrooms. Even before state courts adopt these changes, law schools must teach this rule and bar exams must test on it. Known as 8.4G, the rule provides that it is professional misconduct to engage in discrimination based on race, sex, religion, national origin, ethnicity, disability, age, sexual orientation, gender identity, marital status or socioeconomic status and conduct related to the practice of law. The rule specifies that discrimination includes verbal conduct that manifests bias. If lawyers do not follow this rule, they risk discipline, for example, disbarment, or suspension from the practice of law. The ABA report explaining the rule quotes past ABA President Paulette Brown, who says lawyers are responsible for making our society better, and because of our power, we are the standard by which all should aspire. In case of Rule 8.4G, the standard, for lawyers at least, apparently does not include the First Amendment right to free speech. Consider the following form of verbal conduct when one lawyer tells another, in connection with a case, "I abhor the idle rich. We should raise capital gains taxes." The lawyer has just violated the ABA rule by manifesting bias based on socioeconomic status. More likely consequences include a scenario where, for example, a law firm does not hire a job applicant who seeks a position as a messenger. If this firm designates restrooms by sex, the applicant can always argue that the firm engaged in gender identity discrimination. If the disappointed job seeker identifies with the opposite sex or claims to, he creates leverage by claiming that he was not hired because the firm's restrooms demonstrated gender identity bias. Lawyers hauled before the discipline board will find that the proceedings, unlike courts, are typically not open to the public. There's no jury and the rules of evidence are relaxed. If the disappointed applicant sues, the risk also includes civil liability, derived from violating the new ABA rule. The law firm will face expensive discovery, a gauntlet of motions, and possibly years of litigation, particularly if the applicant files a class action. It is hardly the best use of scarce bar resources to discipline lawyers who may violate a vague rule that prohibits some speech even if the speech relates to conduct that does not violate state or federal law. Yet the new rule offers one possible advantage: it may ameliorate underemployment among lawyers, since so many will be needed to meet the demand the rule creates. Mr. Rotunda is a professor at Chapman University's Fowler School of Law.